Hello, and welcome to another installment of the Environmental Essentials for In-House Counsel webinar presented by Bracewell's Environment, Lands, and Resources Group. I'm Brittany Pemberton, a partner in Bracewell's Washington, D.C. office, and I'm joined this morning by my partner, Jeff Holmstead, who many of you know previously was the head of EPA's Air and Radiation Office during the George W. Bush administration. The topic of this morning's webinar is West Virginia v. EPA. By now, we assume everyone listening in is probably pretty familiar with the court's opinion. So I'll just say quickly that the Supreme Court ruled that EPA's Clean Power Plan under Section 111D was unlawful under what they call the Major Questions Doctrine, because there was no clear statement from Congress authorizing EPA to require a shift in power generation from coal to lower carbon fuels. Rather than wade into the details of the opinion, we wanted to focus this morning on what this means for EPA when it comes to the agency's authority to regulate greenhouse gas emissions going forward. There have been some ambitious proposals to the agency, including most recently a letter from a number of states calling for EPA to establish a NAAQS for greenhouse gases. So we're going to talk briefly about those, as well as some of the more traditional and effective approaches that EPA is likely considering. So Jeff, I know you've given quite a lot of thought to this issue and the case and what may be left for EPA. Do you want to start us off by talking about some of those maybe slightly more left field options?
Sure. Really going back to Mass v. EPA, there have been a number of ideas floated about how EPA can best regulate greenhouse gases under the Clean Air Act. The one that seems to be most in the news these days is the idea that EPA should set a national ambient air quality standard for greenhouse gases. That may be a bit of a surprise to people who are used to the NAAQS and how they have traditionally worked. But in defense of the proponents of those ideas, I will say that if you focus exclusively on the words, you can come up with a plausible reading by which greenhouse gases could be considered criteria air pollutants. They would appear to meet that definition. And the idea that has been proposed is not necessarily that there would be an ambient air quality standard set in terms of a concentration, but that they could set a standard in some other form. So rather than achieving a particular concentration of pollutants in the air, there would be some reduction requirement that would be a standard. So states would have to look at their greenhouse gas emissions as of a certain year, and then the standard would require them to reduce those emissions collectively from the state by some number, 20% or 50% or 90%, depending on how ambitious the proposals are. I will say that back in 2008, when EPA issued its what we call this ANPR, its Advanced Notice of Proposed Rulemaking, they discussed the possibility of setting a NAAQS for CO2, for greenhouse gas emissions, and pointed out a number of the practical difficulties that would create. I won't go into those, because I think the more important thing is, after West Virginia versus EPA, I think that idea is just completely off the table. I can't imagine that the Supreme Court would look at the way the statute has been interpreted for the last 50 years, how it's been understood, how it's worked, and sort of let EPA come up with creative approaches to do something that seems so far beyond what Congress ever intended when it established the program. So I think when it comes to something like that, the Supreme Court was pretty clear that this is a topic of great political and economic significance. And certainly EPA has some tools that the courts have authorized it to use. I think there are some regulatory programs. But in terms of these really ambitious ideas that would allow EPA to create some sort of an economy-wide or even industry-wide reduction requirement for greenhouse gases, I think those are probably off the table after West Virginia v. EPA. You know, I might mention, and Brittany, you've heard me say this before, if really all you're looking for is sort of a plausible reading of environmental statutes, people have proposed a number of ideas. People may have read that not too long ago, there was another petition specifically asking EPA to regulate CO2 under TSCA, under the Toxic Substances Control Act, pointing out that if you strictly look at the definition of a toxic substance under TSCA, that you could argue that CO2 meets that definition. And so there was actually a fairly lengthy petition that included some law professors calling on EPA to use TSCA to regulate CO2 emissions. Others have pointed out, in fact, EPA itself pointed out in 2008 in the ANPR, that just looking at the definition of a hazardous air pollutant, you would have an argument that CO2 and greenhouse gases might qualify as hazardous air pollutants as well. But those of us who work on under Section 111, under Section 112 of the Clean Air Act, which deals with hazardous air pollutants, know that if it were a hazardous air pollutant, you would have millions of major sources that would have to be subject to MAAQS standards for CO2, and that's just completely untenable. Others have even pointed out that under Title VI of the Clean Air Act, because greenhouse gases do have some indirect effect on ozone-depleting substances, that you could arguably regulate them under Title VI as ODSs, as ozone-depleting substances. But again, I think one lesson from the West Virginia case is that having a plausible textual reading is certainly not enough. And if the agency wants to embark upon that kind of extraordinary regulatory program, it would have to be able to point not just to a plausible reading, but to a clear statement by Congress that that's what they intended EPA to do. So, I've quickly covered a lot of ideas. I mean, Section 115 of the Clean Air Act has been proposed as a way that EPA could create a nationwide cap and trade program for CO2. I just think that all those things are off the table unless there's dramatic changes in the Supreme Court and the jurisprudence. And even then, I think many of those ideas wouldn't pass muster even in our current DC circuit, which is likely to be a little bit more sympathetic to EPA's regulatory ambitions. So I have a question for you. I've talked about all the different ways that have been proposed for EPA to regulate greenhouse gas emissions, and why they probably are not tenable after the West Virginia case. But there do seem to be some tools that EPA can use, and I think so far the most aggressive regulation that has been issued or proposed by EPA has to do with regulating greenhouse gases, and in particular CO2 emissions from the transportation sector. I know that you've looked into that, both the rule they've already done and it's some of the ideas that they're looking at. How are those likely to be affected by the West Virginia case?
I think that's a great question. And, the prognosis from my perspective, at least, is that there's a pretty good case to be made that EPA is going to have some of the same problems that it had with the Clean Power Plan if it continues on the path that it set out for itself. Part of the reason for that is that the Biden administration has made abundantly clear that remaking the U.S. vehicle fleet is really one of its major priorities when it comes to addressing the climate crisis. The White House issued an executive order last summer that requires 50% of all new passenger cars and light trucks sold in the U.S. in 2030 to be EVs. So since that time, EPA has basically taken its orders from the top, I think, and taken several actions to try to regulate and reduce greenhouse gases from cars and trucks, all of which require substantial electrification in the next few years, something like 400%, an increase of 400% in electric vehicles by the time we get to model year 2026. The agency's also been pretty clear that current approach, even though it would obviously have greenhouse gas reductions tied to it, is just the start. And really what they want to do is build on the electrification that they're requiring now in the short term for future model years, in an upcoming rulemaking, they plan to require additional electrification for model years 2027 and beyond, and they're going to do the same thing, for heavy duty trucks. So, the question really is whether the vehicle fleet should be electrified. It seems to me to be something of great political debate as well. Congress has tried and failed to pass EV mandates in the past. I think maybe even most recently is 2019 and 2020. And there's obviously a lot of political debate, even when it comes to the incentives for that kind of technology. There's tax incentives that are built into the Inflation Reduction Act. And you hear, sort of great cry at this point in time from the automakers about whether those tax incentives are going to be available to them because of limitations placed on the sourcing of the critical minerals that would be needed for the battery construction for these EVs. So really an open question, I think, about, whether the availability of those tax credits and that restriction means that the EV mandate could actually be accomplished. And it's obviously a matter for Congress, I think, to sort of weigh and balance all of those considerations. All of that, to me, points to a real lack of authority for EPA, especially when you look at the plain language of the Clean Air Act, and we're talking about, Section 202, and all it directs EPA to do is to regulate the emissions from motor vehicles. I think that's a far cry from, requiring a particular technology, something like electric vehicles, and making that the means through which you totally shift the generation, so to speak, of, the vehicle fleet from one technology to another, which is, pretty similar to, I think, what happened in the Clean Power Plan.
Yeah, I've thought the same thing, that, in effect, EPA is trying to limit the number of vehicles that can operate on gasoline and diesel fuel over the next period of time. And it will be interesting to see how that plays out in the courts. I am not familiar with all the details of the Schumer-Manchin deal, which I prefer to call it, instead of the Inflation Reduction Act of 2020 or 2022. But it seems to me that there were obviously incentives for electric vehicles, but also some sort of guardrails based on the availability of critical minerals and incentives for the production of or the mining of critical minerals domestically. And it does seem like those are the sort of issues that can be dealt with by Congress, but difficult to see how those are the kinds of things that EPA is expected to take into account when it's developing its own regulations. I mean, EPA certainly has expertise in lots of areas, but trying to understand the incentives and the disincentives for the mining of critical minerals in the United States and where those might come from do seem like issues that are beyond the jurisdiction of EPA.
Yes, and the fascinating thing I think about that is that EPA knows as much, and they've said that in response to comments on these rulemakings, that there are any number of issues like the upstream emissions related to producing and operating electric vehicles, the critical minerals issue. There are implications for geopolitics and national security there. And EPA says, we note that these comments have been made, but they're outside our expertise and beyond the scope of the rulemaking. So, interesting that they can recognize that there are all of these issues of pretty big significance and political significance tied up in what they're trying to do, and that they don't have the power to address them.
Well, I know that we have listeners to our webinars who are also probably very interested in EPA's efforts to regulate methane emissions from oil and gas operations. Are those likely to be impacted by the West Virginia decision, do you think?
I don't think so. And the reason for that is that, EPA's efforts to date, and they've gone back and forth a little bit, between administrations about whether and how to regulate methane emissions from certain segments of the oil and gas industry. But where they landed in 2016 during the Obama administration, and where they're likely to come out again now, is an approach that I think the court would not have a problem with under West Virginia. And that's because they would regulate the methane emissions. They'd set a standard, but it would be in tandem with regulating VOCs. And the technology application or the efforts that would be required to meet those standards would be the same thing that you're already doing to accomplish those VOC reductions. A lot of that's going to be focused on leak detection and repair and reducing flaring. They may require here and there certain technology, something like a pneumatic controller that might be a zero emitting source going forward, where that hasn't been the case in the past. But it's all about really, clamping down on methane from leaks, more or less.
Right. That really does seem to be sort of right down the fairway in terms of what EPA has done in the past. And that doesn't mean that EPA can do whatever it wants. It would still have to meet the requirements of Section 111B and 111D, but it doesn't seem to implicate the major questions doctrine.
I think that's right, because you don't really see some new and novel approach to a new problem using an old statute.
Well, and again, if the Manchin-Schumer agreement is enacted, I think there's some provisions in there that might actually be read to certainly validate the approach that EPA has taken. As I recall, in that statute, there are sort of minimum standards for methane leaks that EPA's rules would need to achieve in order to allow regulated entities to avoid having to pay the kind of methane fees that are provided for in that act. So, if anything, it seems like Manchin-Schumer deal reinforces EPA's authority, and actually, to some extent, creates an incentive for for the industry to support sort of reasonable rules that deal both with existing and new sources of methane from oil and gas operations.
I think that's right. And I think maybe this takes us to our last kind of big topic of the morning. And that's really what is left on the table for EPA in terms of options when it comes to regulating greenhouse gas emissions from industrial sources. Jeff, I'd love to hear what your sense is of what those options are.
One of the things that you've heard me say now for years is, even though EPA arguably, in fact, clearly has significant regulatory authority when it comes to reducing CO2 emissions from new motor vehicles and engines under Title II of the Act. And even though they would seem to have all the regulatory tools they need to reduce methane emissions, not only from oil and gas operations, but from other sectors, because that's the type of regulation that EPA has traditionally done, I just don't think they have any good tools for regulating CO2 emissions from the industrial sector. And one of the ironies, I think, of West Virginia versus EPA is I don't think it will have any impact on the way the Biden administration was planning to regulate greenhouse gas emissions from the power sector. The folks who are in senior positions at EPA and even in the White House, I think we're very much aware of the problems that the Clean Power Plan would have with this Supreme Court. So even without West Virginia versus EPA, I don't think they were heading down the road of requiring significant generation shifting, which they had done explicitly in the Clean Power Plan. So, if anything, in maybe a funny way, the West Virginia case is actually a helpful thing for the administration, because there were certainly voices in the environmental community who were calling on EPA to do something very aggressive, some even more ambitious approach of the Clean Power Plan to shift generation away from coal and natural gas. I don't think they were inclined to do that, because I think they were quite confident that that wouldn't pass muster in the Supreme Court. And now that I think that pressure has gone away, they can point to the West Virginia case and say, well, we can't do that. We need to be a little more modest in what our regulatory goals are. And it will be interesting to see how they proceed, and even if they proceed with a 111D rule. Again, I've referred several times to the Schumer-Manchin bill or agreement, whatever we call it. And there are very significant tax incentives that I think everyone agrees will significantly reduce CO2 emissions from the power sector. And I don't know that EPA can do much more than even building on what's expected to occur because of those tax subsidies. So I think a real interesting question is, in light of that, assuming it is actually ultimately enacted, and it certainly seems like it probably will be, will they even feel like they need to go through the effort of trying to regulate CO2 emissions directly? And they've also been pretty candid in saying, well, we think we have other ways of restructuring the power sector. And I've been a little surprised at how public they've been. Both the administrator, Michael Regan, and the head of the Air Office, Joe Goffman, have talked about using all of the tools they have, including regulating conventional pollutants, whether you're talking air pollutants or water effluent or even coal ash. There are ways that they believe that they can simply make it more expensive to operate, especially coal-fired power plants. And by making those less economically attractive, they may feel like they can sort of further incentivize the switch away from coal towards other sources. But now with the tax incentive, it's not even clear that that those approaches will be all that meaningful when it comes to sort of transitioning out of coal. Because I think there's a lot of companies who are committed to doing that anyway. And with the tax incentives, the tax subsidies that are now available, it may be that we won't see another 111D rule to regulate CO2 emissions from the power sector. But that kind of leaves us with the rest of the industrial sector. And, if you're looking at cement plants or refineries or chemical plants, iron and steel, which tend to be the biggest sources of CO2 emissions in the industrial side, there is no option like generation shifting. No one has sort of identified a zero carbon way of producing cement. And so the idea that EPA could sort of shut down existing sources and require new types of cement manufacturing facilities to be built, or iron and steel, I think those were never on the table, even before the West Virginia case. And so I just don't think that EPA has meaningful regulatory tools under the Clean Air Act, unless at some point something like carbon capture and sequestration becomes adequately demonstrated, to use the terms of the Clean Air Act. That's been an idea that's been out there. There's certainly people in the environmental community who've said, well, after West Virginia, EPA should just require CCS for existing coal-fired power plants. I don't think that would face an issue under the major question doctrine necessarily, but EPA would still have to show that is a system of emission reduction that's been adequately demonstrated considering costs. And I think they understand that they couldn't make that argument with a straight face.
Yeah, the number of those CCS facilities that are in operation, even around the world, is pretty small, and the track record in the U.S. is pretty poor, I think.
Oh yeah. And although again, there's the potential increase in the 45Q tax credits for carbon capture and storage, and over time, that could certainly lead to technology developments that might work for the power sector, that might work for other industrial sectors. But my impression is that we're still a long way from that. And until something like that is available, I think EPA's regulatory options, and not only regulatory options, but simply the technology options that are available, will continue to need cement, will continue to need chemicals and iron and steel. And so, EPA may look at a 111D rule that would require improvements in energy efficiency, but most of those plants already are trying to use as little fuel as they can. So it'll be interesting to see, but my general view is that we're a long way from having EPA make a serious effort to try to regulate CO2 emissions from industrial sources. So the other observation I've had about the West Virginia case is there certainly seems to be a real tension between the Supreme Court's holding and the Biden administration's effort to have this whole of government approach to deal with climate change. And they've been very public about saying we want every department and agency of the federal government to be involved in the fight against climate change. And when you see other agencies besides EPA responding to those calls by coming up with their own regulatory programs, it seems like that that could certainly be an issue. Brittany, I know you've been following a couple of those, but where else might we see that the major question doctrine come into play?
Yeah, I mean, I think while we're still on the topic of EPA, I've certainly seen folks talking about the issue with regard to the waters of the United States and maybe even the Sackett case that's going to be argued at the Supreme Court on the first day of the term in October. So that's one to keep an eye on. I think also, if you're looking for a clear congressional statement about the ability to jump into the fray when it comes to addressing climate change, you have to wonder whether the SEC is really the right agency for that. They've certainly issued a proposal that has quite a lot in it related to climate disclosures. If that gets finalized, I think that could be a potential rulemaking that somebody at the Supreme Court might look closely at. I'm certainly not an expert, when it comes to SEC regulation, so I'll leave it there. But I think the other one that's potentially has a bullseye on it is probably some of the recent actions that the Federal Energy Regulatory Commission actions and policies. I think that they've been considering when it comes to how to analyze and take into account the greenhouse gas emissions of some of the projects that they authorize. I'm not sure that there's a clear congressional statement for those either.
Well, again, I'm not a FERC expert either, but I think it goes beyond just whether they can consider greenhouse gases under NEPA, which is certainly an issue. But I believe the proposal was that under the Natural Gas Act, when they consider whether a pipeline is in the public interest, they at least claim to seem to believe that they could say, well, because of climate change concerns, we find it's not in the public interest. And that would certainly seem to be a departure of however many decades of decisions under the Natural Gas Act. So I don't know that the major question doctrine will come into play in every single regulatory case. In fact, I still think it will be a relatively narrow slice, but there are certainly some interesting cases that we could see come up in the next few years.
Well, and with that, I think we're out of time for this morning. So we want to thank everyone for joining us. If you have any questions about this morning's webinar, I'm sure Jeff or I would be glad to, get on the phone or a video with you and to talk more about it. Hopefully you can tell by the tone of our voice that, we both really enjoy talking about these issues. So it would be a pleasure to speak with any of you about it further. So just feel free to reach out to us and please keep an eye out for further invitations to other webinars